cases I'm going to talk about that were significant for tort law. One, and again, tort law is based on precedents, that is, other cases where judges made decisions, and statutes. They it doesn't like establish a law unless the legislature turns it into law, but it's a precedent that future cases the judge looks to in future cases. So two of the cases I'm going to talk to you about do that. They set a precedent, and I'm going to tell you what you got out of it, how I would associate it, how I would remember it. So Donoghue versus Stevenson established the doctrine of negligence. So you see, like the nog in neg, and so I would connect that together. Maybe call it Donogligence to help you remember to put the two together. So what actually happened was this woman, and it was in 1936, I think. This woman was at a cafe, a Scottish cafe, and she drank a ginger beer. I love ginger beers, so this one really affected me. It had a decomposed snail in it, and that made her ill, and so she sued the manufacturing company, which would be Stevenson, and she won. And what was established is that the manufacturers have a certain duty of care to those affected by the products that they create, and even though they had no contract to argue breach of contract, there was still the duty of care, and that case established the doctrine, what's called the doctrine of negligence. Okay, then the next case that's important and that I'm going to talk about is Byrne versus Boadle. You can see they're both B for Byrne, B for Boadle, and it involved a barrel of flour. So this man was walking by. Byrne was, because he becomes the plaintiff, and all of a sudden he goes unconscious. Witnesses said that he had a barrel of flour roll off and hit him, but he didn't. The witnesses didn't see anything like intentional, that anybody intentionally rolled that barrel off on him. So anyway, he sued, and what came out of that is res ipsa loquitur. I might not be pronouncing that right. So the way you can remember that, it looks like recipe, right? R-E-S-I-P, recipe for disaster is how I would put that together. Which it actually means that you can prove someone is negligent kind of like by default. Like barrels don't just roll off by themselves out of nowhere. It's like a recipe for disaster. Like you can see an accident coming, right? Even though nobody's intentionally, maybe the practices are not safe enough. Like, well, I'll let you look up examples of that. But so it's where plaintiffs use this recipe for disaster. The res ipsa loquitur is a tort law doctrine allowing plaintiffs to use circumstantial evidence to establish a rebuttal presumption of negligence when direct proof is lacking. It applies if the incident typically requires negligence, like it's not going to just fall off on its own. Somebody must have not fastened it down. This does remind me of a situation where somebody I knew personally died from a truck that was carrying these round metal pipes, and one slid off, crashed through her windshield, smashed her face. She lived a couple of days, and then she passed away at a young age. How tragic. But it's like a recipe for disaster. So I don't drive behind trucks carrying things. So what the attorney this for the plaintiff has to prove is that the accident of this type does not, in order to argue this ibs this res ipsa loquitur. Remember recipe. That's how I forgot it, as you can tell by listening to me, but that helped me get it back, the recipe thing. So the accident of what you have to prove is that this type does not ordinarily occur without negligence. It doesn't ordinarily occur that way. Uh, and again, in this case, this barrel, you don't typically have to watch out for. He was just walking down a road, and this happened to him. So you don't normally have to look up to find a barrel, to watch out for barrels falling on you. Nowadays, surely there's going to be a lot of law involving drones and delivery. Like we might need metal umbrellas or some kind of shield above our heads, right? But back then, they didn't, barrels of flour didn't fall from the sky. I have another situation of a friend I knew, or a woman I knew, who was walking down the road after a rainstorm, and you know how limbs fall after rain because they get full of water, and if they're not strong, a lot of times they just fall off. So right as she was walking under um, a tree, a limb fell on her. So it doesn't normally happen that you have to worry about it. The instrument causing injury was under the exclusive control. Like the case of the tree, that wasn't really under control of anybody. Um, Perhaps it could be argued that way. But anyway, so uh, the flower, it has to, you have to prove these things in order to argue that the instrument causing the injury was under the exclusive control of the management of the defendant, that is the flower company, and the injury was not caused by any voluntary action or contribution of the plaintiff. That is, the plaintiff didn't have anything to do with it at all.